Sexual harassment happens almost every day in our lives. We barely notice it because sometimes sexual jokes or remarks have been common nowadays. However, only a few of us are aware of the dangers that has been brought by ignoring sexual harassments in the workplace, educational institutions, and in public places. Our topic for today is to raise awareness, especially to new ones who will yet to experience the complications and intricacies of employment. This video will guide and aid you in identifying acts that constitute sexual harassment to protect you from harm in the workplace and in public places. In the Philippines, we have two laws that govern anti-sexual harassment. We have Republic Act number 7877, otherwise known as the Anti-Sexual Harassment Act of 1995, which prohibits sexual harassment in the employment, education, or training environment. We also have Republic Act number 11313, or the Safe Spaces Act, which prohibits sexual harassment in streets, public spaces, online, workplaces, education or training institutions that are not covered under Republic Act number 7877. Let's start with Republic Act number 7877. What constitutes sexual harassment? Under Republic Act number 7877, work, education, or training-related sexual harassment is committed by an employer, employee, manager, supervisor, agent of the employer, teacher, instructor, professor, coach, trainer, or any other person who, having authority, influence, or moral ascendancy over another in a work or training or education environment, demands, requests, or otherwise requires any sexual favor from the other, regardless of whether the demand, request, or requirement for submission is accepted by the object of the said act. So take note here that sexual harassment in work, education, or training related is committed by an employer, employee, manager, supervisor, teacher, instructor, professor, who has the authority, influence, or moral ascendancy. What is the gravamen of sexual harassment under Republic Act number 7877 is the abuse of authority. And by using that authority in order to demand, request, or require any sexual favor from the other, even if that sexual demand or favor was not accepted by the victim. Under Civil Service Commission Resolution number 01-0940, the administrative offense of sexual harassment is an act or a series of acts involving any unwelcome sexual advance, request, or demand for a sexual favor or other verbal or physical behavior of a sexual nature committed by a government employee or official in a work-related, training, or education-related environment of the person complained of. And take note here, the offender here must have also used his authority in order to perpetrate the crime of sexual harassment. So what are the acts that constitute sexual harassment in work-related employment environment? Sexual favor is made as a condition in the hiring or in the employment, re-employment, or continued employment of said individual, meaning to say, you will not hire the person if he or she will not accept the sexual demand or sexual favor, or in granting said individual favorable compensation, terms of conditions, promotions, or privileges. It means to say that you will promote the person if he will accept the sexual demand or favor. Or the refusal to grant the sexual favor results in limiting, segregating, or classifying the employee, which in any way would discriminate, deprive, or diminish employment opportunities or otherwise adversely affect said employee, which means to say that you will dismiss or you will terminate the employment if he or she will not accept the sexual favor or sexual demand. The above acts would impair the employee's rights or privileges under existing labor laws, meaning to say, if the employee will not accept the sexual demand or the sexual favor, it will affect his rights under the labor code, such as, for example, his salary. The employer may discriminate the employee by not giving him or her his or her salary. Or the above acts would result in an intimidating, hostile, or offensive environment for the employee, which means to say that the employee is intimidated, or uh, she doesn't feel to be working at all in the workplace because of the sexual harassment acts. So in an education or training environment, sexual harassment is committed against one who is under the care, custody, or supervision of the offender, against one whose education, training, apprenticeship, or tutorship is entrusted to the offender, like for example, the teacher and his or her student. When the sexual favor is made a condition to the giving of a passing grade, like you will give a passing grade if the student will accept the sexual demand or sexual favor, or the granting of honors and scholarships, or the payment of a stipend, allowance, or other benefits, privileges, or consideration, or when the sexual advances result in an intimidating, hostile, or offensive environment for the student, trainee, or apprentice. So it doesn't confine itself to giving of a passing grade. So if the sexual act or sexual advances will result into an intimidating, hostile, or offensive environment for the student, then that will already constitute sexual harassment committed in education or training environment. Is sexual harassment limited to the person who actually committed the sexual harassment? The answer is no, because under Section 3, any person who directs or induces another to commit any act of sexual harassment, as herein defined, or who cooperates in the commission thereof by another without which it would not have been committed. Meaning to say that if a person helps or cooperates with the commission of sexual harassment, even if that person did not commit the sexual harassment, he or she shall also be held liable under Republic Act number 7877. We said earlier that under Republic Act number 7877, sexual harassment may take place in the workplace, education, or training environment. So where exactly sexual harassment may take place? Sexual harassment may take place in the premises of the workplace or office or of the school or training institution. In any place where the parties were found as a result of work or education, training responsibilities, or relations. So even if the sexual harassment did not take place exactly in the workplace or in the school or training institution, for as long as the place is the intended place where the parties are found as a result of their work or education or training responsibilities, then sexual harassment can still take place. At work or education or training related social functions. For example, if there is a JS prom for the students and the JS prom was held in a hotel, since the JS prom was conducted as an education or training related social function, any act of sexual harassment that may have been done or may have been taken place in that hotel may constitute sexual harassment under the law. And therefore, the teacher or the trainer can still be liable for sexual harassment under Article 7877. While on official business outside the office or school or training institution or during work or related training, travel. Like for example, if the employee and his boss or supervisor has a seminar that will take place outside their office, like they will go to Manila to attend a seminar, and sexual harassment has taken place in the place where the seminar was conducted. So even if it is outside the office or the employment institution, sexual harassment may still take place. And this supervisor can still be liable under Republic Act number 7877 because they are on official business outside the office. At official conferences, fora, symposia, or training sessions, just like what I said earlier, by telephone, cellular phone, fax machine, or electronic mail. So even if sexual harassment was merely committed via cellular phone, your employer calling you, making sexual advances, or making sexual demand, sexual harassment may still take place. He can still be liable, provided you support your claims with evidence. Now let's go to the illustrative forms of sexual harassment. We have physical, like malicious touching, overt sexual advances, gestures with lewd insinuation. Just like, for example, what you have seen on the screen. The male person here touches the female's butt. And the other photos which shows that the male person grabbing the hands of a female employee. Sexual harassment may also be verbal, like saying requests or demands for sexual favor, or lurid remarks like you will say slut to a female employee, or you will talk green jokes to the other employee. But take note that sexual advances or sexual harassment is also committed by persons of the same sex. It is not limited to a male and a female employee. It can be committed by a female against a male employee, a male against a female, or may be committed by a female against a female employee, for as long as the offender here has the authority, influence, or moral ascendancy over the other. Or sexual harassment may also be committed by the use of objects, pictures, or graphics, letters, or writing notes with sexual underpinnings, like you will read an FHM magazine while your coworker is beside you, and the coworker can see what you are doing. So that will also constitute sexual harassment. Sexual harassments in the workplace, education, or training environment are committed in secret. And some of the victims here are afraid to tell or afraid to divulge what happened or any sexual harassment that happened against them. So in order to protect these victims or these supposed victims, the law imposes a duty on the part of the employer or the head of office in order to prevent or deter the commission of acts of sexual harassment. Otherwise, sexual harassments may not be discovered, and it may continue in the workplace or in education or training environment. So under Section 4, it shall be the duty of the employer or the head of the work-related education or training environment or institution to prevent or deter the commission of acts of sexual harassment, and to provide the procedures for the resolution, settlement, or prosecution of acts of sexual harassment. In addition, the law provides that the employer or the head of office shall promulgate appropriate rules and regulations in consultation with and jointly approved by the employees or students or trainees through their duly designated representatives, prescribing the procedure for the investigation of sexual harassment cases and the administrative sanctions therefore. Administrative sanctions shall not be a bar to prosecution in the proper courts for unlawful acts of sexual harassment. So this basically means that if the employer or the supervisor was found administratively guilty of sexual harassment and the employer imposes administrative sanctions, it does not prevent the filing of a criminal case in the proper court. So it means that the offender may be liable both for administrative offense and also for criminal offense. The said rules and regulations issued pursuant to this subsection shall include, among others, guidelines on proper decorum in the workplace and educational or training institutions. The employer or the head of office shall also create a committee on decorum and investigation of cases on sexual harassment. The committee shall conduct meetings, as the case may be, with officers and employees, teachers, instructors, professors, coaches, trainers, and students or trainees to increase understanding and prevent incidents of sexual harassment. It shall also conduct the investigation of alleged cases constituting sexual harassment. In the case of a work-related environment, the committee shall be composed of at least one representative, each from the management, the union, if any, the employees from the supervisory rank, and from the rank and file employees. In the case of the educational training institution, the committee shall be composed of at least one representative from the administration, the trainers, instructors, professors, or coaches, and the students or trainees, as the case may be. The employer or head of office, educational or training institution shall disseminate or post a copy of this act for the information of all concerned. So what is the liability of the employer, head of office, education or training institution in cases of sexual harassment? The employer or head of office, educational or training institution shall be solidarily liable for damages arising from the acts of sexual harassment committed in the employment, education, training environment if the employer or head of office, educational or training institution is informed of such acts by the offended party and no immediate action is taken. So this is the liability imposed by the law. If the employer will not act upon any complaints for sexual harassment in the workplace, education, or training environment, so the employer will be solidarily liable to pay for whatever damages that may arise from the acts of sexual harassment. Section 6, Independent Action for Damages. Nothing in this act shall preclude the victim of work, education, or training related sexual harassment from instituting a separate and independent action for damages and other affirmative relief. Penalties. Any person who violates the provisions of this act shall upon conviction be penalized by imprisonment of not less than 1 month, nor more than 6 months, or a fine of not less than 10,000 pesos, nor more than 20,000 pesos, or both, such fine and imprisonment at the discretion of the court. Any action arising from the violation of the provisions of this act shall prescribe in 3 years. So if the Sexual Harassment Act was committed today, so you have 3 years from today to file an action for sexual harassment. So let's take up this case of Baksin versus Amihan. GR number 146053, decided on April 30, 2008. The facts of the case are as follows. Petitioner here is a public school teacher of Pandan Elementary School. Respondent Eduardo O. Wahiman is the father of AAA, an elementary school student of the petitioner. AAA claimed that on August 16, 1995, petitioner asked her to be at his office to do an errand. Once inside, she saw him get a folder from one of the cartons on the floor near his table and place it on his table. He then asked her to come closer, and when she did, held her hand, then touched and fondled her breast. She stated that he fondled her breast 5 times and that she felt afraid. A classmate of hers, one Vincent B. Sorabas, claiming to have witnessed the incident, testified that the fondling incident did happen just as AAA related it. In his defense, petitioner claimed that the touching incident happened by accident, just as he was handing AAA a lesson book. He further stated that the incident happened in about 2 or 3 seconds, and that the girl left his office without any complaint. So if you will try to analyze the problem, here, the sexual harassment is in the form of physical touching, because the suspect here fondled the breast and held the hand of the victim, AAA. And aside from that, and because of that, physical touching, it created an intimidating, hostile environment on the part of AAA. So the issue in this case is whether or not petitioner is guilty of sexual harassment. The decision of the Supreme Court was the formal charge, while not specifically mentioning RA 7877, the Anti-Sexual Harassment Act of 1995, imputes on the petitioner acts covered and penalized by said law. Contrary to the argument of the petitioner, the demand of a sexual favor need not be explicit or stated. In Domingo versus Rayala, it was held, it is true that this provision calls for a demand, request, or requirement of a sexual favor, but it is not necessary that the demand, request, or requirement of a sexual favor be articulated in a categorical oral or written statement. It may be discerned with equal certitude from the acts of the offender. Because here in this case, the teacher said that he did not say anything or he did not say any sexual favor demand to the student. What he did is that he immediately fondled the breast of the student and held her hand. So, the Supreme Court said that the demand is not necessarily oral or written. It may be discerned with equal certitude from the acts of the offender. Since the act of the offender resulted into an hostile, intimidating environment on the part of the student, then that is enough to constitute sexual harassment. Republic Act number 7877 is limited only to sexual harassments that take place in the workplace or in an educational or training related environment. So if there are sexual harassments that are committed by a complete stranger in a street or online, then RA 7877 is not applicable. This leads us to the next law, which is Republic Act number 11313 or the Safe Spaces Act. Since sexual harassment is not only committed in the workplace, educational training environment, the law finds it necessary to prevent also sexual harassments in public places. Hence, the Safe Spaces Act, or popularly regarded as the Anti-Bastos Law, was passed. RA number 11313 is an act defining gender-based sexual harassment in streets, public spaces, online, workplaces, and educational training institutions, providing protective measures and prescribing penalties therefore. Now let's learn the terms under this law. Gender refers to a set of socially ascribed characteristics, norms, roles, attitudes, values, and expectations identifying the social behavior of men and women and the relations between them. Gender identity and or expression refers to the personal sense of identity as characterized among others by manner of clothing, inclinations, and behavior in relation to masculine or feminine conventions. A person may have a male or female identity with physiological characteristics of the opposite sex, in which case this person is considered transgender. So there are people saying that gender and sex are two different terms because sex, the basis of sex is the biological, the biology of a person, while gender, this is based on the identity and expression of the person. So a person may have a male gender but with a female sex. So that is what we mean by these terms. Public spaces refer to streets and alleys, public parks, schools, buildings, malls, bars, restaurants, transportation terminals, public markets, spaces used as evacuation centers, government offices, public utility vehicles, as well as private vehicles covered by app-based transport network services, and other recreational spaces such as but not limited to cinema halls, theaters, and spas. Gender-based online sexual harassment refers to an online conduct targeted at a particular person that causes or likely to cause another mental, emotional, or psychological distress and fear of personal safety. Sexual harassment acts including unwanted sexual remarks and comments, threats, uploading or sharing of one's photos without consent, video and audio recording, cyber stalking, and online identity theft. So this is very common nowadays. Catcalling refers to an unwanted remarks directed towards a person, commonly done in the form of wolf whistling and misogynistic, transphobic, homophobic, and sexist slurs. Stalking refers to conduct directed at a person involving the repeated visual or physical proximity, non-consensual communication, or a combination thereof that cause or will likely cause a person to fear for one's own safety or the safety of others or to suffer emotional distress. The crimes of gender-based treats and public spaces sexual harassment are committed through any unwanted and uninvited sexual actions or remarks against any person, regardless of the motive for committing such action or remark. So, if we try to distinguish this from RA 7877, RA 7877 is limited only to sexual harassment in employment, education, or work-related environment. But here, in Republic Act number 11313, this is very general, meaning any uninvited sexual actions or remarks against any person, regardless of the motive. So you can now be liable for sexual harassment under this law, even if it is committed outside your work, education, or training-related environment. So examples are catcalling, like you're telling the person, hey, is that for me? Where are you going, beautiful? Hey, good looking, sweetie, can I get a pretty smile? So these are examples of catcalling. Wolf whistling, like with you. Unwanted invitations, and sexist slur, like you will tell the person ugly, cheap, blonde, bimbo, bitch, whore, skank, slut. So these are examples of gender-based sexual harassment. Now, gender-based online sexual harassment includes acts that use information and communications technology in terrorizing and intimidating victims through physical, psychological, and emotional threats, unwanted sexual and misogynistic, transphobic, homophobic, and sexist remarks and comments online, whether publicly or through direct and private messages. So, if a person chats you and messaging you with any unwanted or sexual remarks, so that person is liable for gender-based online sexual harassment. Invasion of victims' privacy, like you will screenshot the picture of a woman naked and you will share this to your friends in the group chat, then that is already a gender-based online sexual harassment. Through cyber stalking and incessant messaging, uploading, and sharing without the consent of the victim. Any form of media that contains photos, voice, or video with sexual content, any unauthorized recording and sharing of any of the victim's photos, videos, or any information online, impersonating identities of victims online, or posting lies about victims to harm their reputation, or filing false abuse reports to online platforms to silence victims. So, anything that is sexual harassment online are under gender-based online sexual harassment. So what are the penalties for sexual harassment under Republic Act number 11313? For acts such as cursing, wolf whistling, catcalling, leering, and intrusive gazing, taunting, pursing, and wanted invitations, misogynistic, transphobic, homophobic, and sexist slurs, name, contact, and social media details or destination, the use of words, gestures, or actions that ridicule on the basis of sex, gender, or sexual orientation, identity, and or expression, including sexist, homophobic, and transphobic statements and slurs, the persistent telling of sexual jokes, use of sexual names, comments, and demands, and any statement that has made an invasion in a person's personal space or threatens the person's sense of personal safety. So, the first offense should be punished by a fine of 1,000 pesos and community service of 12 hours inclusive of attendance to a gender sensitivity seminar to be conducted by the PNP in coordination with LGU and the PCW. For the second offense, the person is punished by arresto minor, which means that 6 to 10 days of imprisonment or a fine of 3,000 pesos. Third offense shall be punished by arresto minor, 11 to 30 days of imprisonment, and a fine of 10,000 pesos. For acts such as making offensive body gestures at someone and exposing private parts for the sexual gratification of the perpetrator with the effect of demeaning, harassing, threatening, or intimidating the offended party, including flashing of private parts, public masturbation, grouping, and similar lewd actions. The first offense shall be punishable by a fine of 10,000 pesos and community service of 12 hours, inclusive of attendance to a gender sensitivity seminar to be conducted by the PNP in coordination with the LGU and the PCW. The second offense shall be punishable by arresto minor, 11 to 30 days of imprisonment, or a fine of 15,000 pesos. And for the third offense, the person shall be punished by arresto mayor, 1 month and 1 day to 6 months of imprisonment, and a fine of 20,000 pesos. For acts of stalking and any of the acts mentioned in Section 11, paragraphs A and B, when accompanied by touching, pinching, or brushing against the body of the offended person, or any touching, pinching, or brushing against the genitalia, face, arms, anus, groin, breasts, inner thighs, face, buttocks, or any part of the victim's body, even when not accompanied by acts mentioned in Section 11, paragraphs A and B. First offense should be punished by arresto minor, 11 to 30 days of imprisonment, or a fine of 30,000 pesos, a fine rather, provided that it includes attendance in a gender sensitivity seminar to be conducted by the PNP in coordination with the LGU and the PCW. Second offense should be punishable by arresto mayor, 1 month and 1 day to 6 months of imprisonment, or a fine of 50,000 pesos. And the third offense shall be punishable by arresto mayor in its maximum period or a fine of 100,000 pesos. Okay, that is all for anti-sexual harassment laws in the Philippines. Thank you for listening.